Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference. Per Bagley King requirements, all cameras must be kept on during the duration of the meeting. If you're unable to have your camera on, you must indicate a reason for your non-appearance during the meeting. Please be aware of the surroundings behind you. All meetings will be recorded and posted to the State Bar's website. Zoom captioning is available to enable. Select live transcript at the bottom of your screen and then select enable auto transcript. Thank you.
Thank you so much. And I think we're going to do roll call if you're done with your announcements, Kim. So Erica, could you do that?
Sure. Blakemore?
Here.
Alsaroff?
Here.
Connolly?
Here.
Wong?
Here.
Mahoney? Sandville? And then I'll do liaisons and State Bar staff. Selena Copeland?
I'm present.
Melanie Snyder? And then I see that myself, Dwan, and Raul, and Sylvia are here. Thank you.
All right, so we have a quorum. So it seems like our next item will be for public comment. We're asking that public comment be limited to 3 minutes if there are any public comments, and that they be related to the items that we're discussing today on our agenda. So Kim, could you see if there is any public comment? And I know there's one person that is, maybe we'll just start with that. Actually, that might be the easiest, right? To start with the person that's with you, Erica.
We have someone here in person.
Yeah. Welcome.
Good morning. Sorry, good afternoon, all members. My name is Kion from Sacramento. I would like to talk about State Bar's integrity issues. Sacramento DA office and police provide me fake information about the death of my father, Woon Kong On. DA case number 99F08735. I filed complaint against Sacramento DA, Mr. Tien Ho, and attorney, Mr. Robert Bronter, because they did not investigate. I report those incidents to their agency back in January 2024. In February, State Bar used an incorrect reason to dismiss my complaint and claim it is a civil matter. Then State Bar intentionally keep delaying to process my complaint review request. In September, State Bar closed my complaint without ruling the DA case 99F08735 to confirm my father, Woon Kong On, was the victim, and Jung So Fong was sentenced for hit and run that killed my father in the case. Also, the letter from State Bar has no name, no title, and no signature. I cannot verify if my complaint were closed by authorized State Bar staff. State Bar is helping to cover up a Sacramento law enforcement scandal. I have requested an internal investigation, but it didn't help. I just emailed the detail and the evidence to this committee. All committee members, why you serve State Bar that has integrity issue? How State Bar is qualified to examine and regulate attorney in California? Please help to keep an integrity State Bar and integrity legal system. I believe all the people who serve State Bar should know about this incident. Please help to ensure an internal investigation will be conducted inside State Bar. Thank you. Thank you all for your time.
Thank you.
Right, thank you for the public comment. And Kim, could you let us know if there are other public comments?
It's one person and I'll allow them to speak.
Thank you.
They should be able to
Lindsay.
talk.
Hi.
Welcome. Hi, Lindsay.
Hi, this is Lindsay Nako, the Executive Director of the Impact Fund. I submitted a written comment yesterday evening. It wasn't within the 24-hour cutoff, and so I'm prepared to make a public comment now. But if you received my written comment and it's submitted, then I don't need to make a public comment at this time.
I believe it was sent to all of the members of the committee this morning.
Okay, wonderful. Thank you all so much.
Thank you. Are there any other comments?
No, that was the last person.
Okay, thank you so much. So we are now going to return to our agenda. I'm going to do a brief chair's report, and then we'll follow that with a staff report if there is one. So I just wanted to bring to everyone's attention that the item relative to the support centers has been removed from this agenda and will be taken up at a later time, and just offer some explanation for that. We originally planned it for this meeting, and as the State Bar staff always does, sent it up for public comment. We received a number of public comments, including, I think, 10 of them directly from support centers, along with the LAC public comments. And we want to make sure that the working group of the committee has time, along with our staff, to look at all of the comments that were received and make a decision about whether there need to be adjustments. We've also asked that the staff identify some additional ways that we could do focus groups with members of the support center community before modifying the rules. So our intention is to do a standalone rules committee meeting sometime in early 2026 to have a new set of rules to go through at that time, and allow plenty of opportunity for public comment if there are some at that meeting. So that is our plan for that agenda item. So with that, I'll see if staff has any comment.
Thank you,
Report.
Catherine. Yeah, just a brief update on some other work of the rule committee, past work, rules that were proposed by the committee that have gone through the commission. Just wanted to update you that those that were approved by the commission at their meeting back in August are going to be going to the State Bar's Board of Trustees at their November meeting. And so assuming that those rules are adopted, they'll be incorporated before the end of the year, and then staff will be working to implement those new rules, update grantees. We plan on hosting a webinar to acquaint them with these new requirements and make sure that everybody is kind of aware of the new rules that are going into effect. So that will be happening in the next few months. And then any rules that are recommended by the committee today will go to the commission at your meeting next week for release for public comment. So, and we'll talk a little bit later about kind of the work plan for 2026. So.
Terrific. Thanks so much, Erica. I believe that takes us to the August 22nd minutes, which is our last committee meeting. Are there any questions or comments about the minutes? Okay, not seeing any. Is there a motion?
I'll move.
I'll second them.
Is staff clear about who moved?
Yes, Connolly
Okay.
moved and Alsaroff seconded.
Terrific. I couldn't hear the first person. Any further discussion? Okay. Could you do the roll call, please?
Sure. Alsaroff,
Yes.
Connolly,
Yes.
Wong,
Yes.
Mahoney, Sandville, Blakemore.
Yes.
4 yeses, no nos, the motion passes.
Okay, thank you. That's going to take us to the first item of business, which is approval of recommendation regarding amendments to real property purchasing. And I think Raul Duran is going to, maybe with others, lead us through that proposal. Thanks for joining, Raul.
Hi, yes. I hope you can all see my screen.
Mhm.
So back in March, we presented on the scope of the State Bar's existing policy regarding the purchase of real property with grant funds. As part of that discussion, I presented on some of the ways that the policy works, as well as the important distinctions between how the Legal Services Corporation approaches the same issue. You should have seen in the agenda item posted with this the existing policy as well as the proposed revisions. And so I don't want to go over unless there's questions too much about how the existing policy works, but mostly summarize what those proposed revisions were. The existing policy has been in place since 1986, and I don't think it's been revised since. So part of the point of this revision was an intention to revisit and update the policy as needed. And then at the March meeting, based on the discussion and the comparisons to the approach of the Legal Services Corporation, I took the feedback from this committee and used it to propose certain revisions that I will now discuss. As sort of a big picture reminder about how the policy operates, it broadly defines what type of expenditures are considered real property purchases. It requires the Legal Services Commission to give prior approval before a grantee can use grant funds for such purchases. It also imposes limitations on those expenditures to ensure that they promote the purposes of the Act, essentially the provision of legal services to the indigent. One way it does that is that it makes sure that the purchases are not for properties that are overpriced and ensures that the purchase leads to some benefit to the grantee to ensure that it improves their ability to provide legal services to the indigent. The guidelines provide an overall procedure for that approval. And finally, sort of as a way to ensure the State Bar's and Legal Services Trust Fund Commission's interests, grants a security interest to the State Bar to the real property for an amortization period, a short period of time during which any sales of or transfers of that property, if it results in net proceeds, have to go back toward the service providing legal services to the indigent. Okay. So the first proposed change was to clarify that the policy only applies to IOLTA funds. So previously this was unspecified. Now we've proposed to rename the policy the Guidelines for Purchases of Real Property with IOLTA Grant Funds to make clear that it only applies to such funds, and then also include a footnote stating that equal access funds and other special legislative grants, because of their often unique restrictions and oversight needs, cannot be used for the purchase of real property. So in general, the categories of expenditures that are listed in the policy would not be appropriate uses of EAF and other grant funds. One of the other suggested changes was to simplify the amortization period. So in the existing policy, there is a 5-year period during which if the transfer of property occurs during that time period, as I said before, any proceeds need to go back toward the provision of legal services to the indigent. However, the policy had this assessment available where that period could be for a shorter time. So if the total aggregate occupancy costs during that period would not exceed the aggregate occupancy costs for a similar rental property, we would have shortened the amortization period. To illustrate how that works, if, for example, a grantee would have spent $250,000 in renting over 3 years, but instead the aggregate occupancy costs for that period were below 250,000, say 245,000 in the 3rd year, we would remove the amortization period and no longer restrict further transfers of the property. So the feedback received was sort of one to make this sort of a simpler process and consistent across grantees. So rather than having this cost benefit assessment, it would just be a standard 5-year amortization period for all grantees. It would reduce sort of the administrative burden of needing to conduct cost benefit assessments and would be applied consistently across all grantees. I also just wanted to remind the committee that this is a distinction from the way the Legal Services Corporation handles their interest in real property. The Legal Services Corporation takes a perpetual interest, so it could be decades later, and the grantee would still need to track the expenditures to ensure that if a transfer occurred, any proceeds went back to the provision of legal services for the indigent. There's also a distinction that the Legal Service Corporation took into account the appreciation of the property. So both the perpetual interest and sort of tracking potential appreciation of properties was viewed as potentially excessively burdensome here. So the feedback we got was to have a standard 5-year period. The next change is to remove the restriction on the property being leased to others or for being used by grantee programs that are for unqualified uses. So the previous limitation, although discretionary, expressed basically a sort of a disfavor toward the use of real property in such cases. The view was that this was an unnecessary limitation, especially in light of the Legal Services Trust Fund retaining broad discretion to deny an expenditure where it appears that it's designed or intended to evade the purposes of the guidelines. The idea being the commission can still choose to deny expenditure if it seems that it's undermining the intent of promoting the provision of legal services to the indigent. This is an approach that is consistent with the Legal Services Corporation's policy. They do not express a disfavor toward leasing part of the property to others or for unqualified program uses. Another change was to increase the de minimis threshold. So the existing policy's threshold was for $5,000 or 5%, sorry, the lesser of $5,000 or 5% of the total grant funds in the year for the grantee. This seemed fairly low and out of date, especially in light of this policy being adopted in 1986. So this was increased to the lesser of 50,000 or 10% of the grant amount, and applies not to individual transactions, but to the aggregate real property expenditures in a year. The thought here was to prevent minor real property expenditures from being subject to the requirements of the policy, such as the pre-approval requirement, the amortization requirement, and would not penalize smaller grantees who may be more likely to hit the lesser of 5% amount. So the increase would be to now the lesser of 50,000 or 10% of the annual grant amount. This is a distinction from the way the Legal Services Corporation handles their real property purchasing policy, their policy does not have a de minimis threshold. So a thought was also made to exempt debt payments that are equivalent to rent paid for an equivalent property. These would not be treated as real property purchases under the policy. They would still be submitted as part of a budget, but it would not be subject to the amortization requirement or the criteria that evaluate whether or not this is sort of would provide long-term benefits to the grantee. The idea is to avoid imposing greater compliance obligations on grantees who have purchased real property than had they simply leased the property, if indeed the debt payments and the rental payments would functionally be equivalent. This approach is an update to the policy and, sorry, a proposed update to the guidelines, and is consistent with the approach of the Legal Services Corporation. So previously the policy included within the definition of real property expenditures, capital improvements, and down payments. This proposed change at the suggestion of staff was to make capital improvements and down payments considered not qualifying expenses, and not an allowable use of grant funds. The goal here is to prevent large one-time costs from being diverted away from the direct provision of legal services. And also to avoid that they could inflate the appearance of service-related spending, may be associated with increased risk of misuse, and as I said, because it could divert from funds directly devoted to the provision of legal services, could result in delayed benefits to the provision of legal services. Important note on this, it would only apply to capital improvements and down payments that are aggregated with other real property purchases in a year in excess of the expenditures for renting an equivalent property. So those are big picture the revisions, the proposed revisions to the guidelines. I do want to say we circulated these proposed revisions to the Aid Association of California, which provided its feedback and essentially endorsed all these changes. They promote the IOLTA clarification so that grantees are clear about which funds are appropriate for the purchase of real property. They support the amendment to the amortization period for consistency, as they viewed it would be equitable for all grantees and a predictable timeline. They've approved removing the restriction on leasing and unqualified uses, as they express that grantees are often exploring creative solutions in this time of downsizing in-person needs, and it was an unnecessary restriction. The de minimis change was also approved because of the prior limit being fairly low, and would treat would now also treat renters and purchasers more equally. And finally, the capital improvements / down payments no longer be considered qualifying expenses was supported because of the view that it could result in large swings of funding in one county. So I'm happy to discuss and answer any questions. This was the proposed resolution for this. This policy, as you know, has not been updated since 1986. So the thought that it's a policy that made sense to send out for public comment period.
Thanks, Raul. Are there commission members who have questions or comments? Committee members, I guess.
I
Erica, go ahead.
Yeah, I just wanted to confirm my understanding. So, because I think it looks great, like no issues with it, but just wanted to make sure. So the idea would be you could use IALTA funds for these real property like capital expenditures, but you couldn't count them as qualified expenditures anymore. So that's the sort of thrust of that, right?
I'm sorry, can you just repeat that one more time?
Sure, yeah. So you could use IALTA funds for like a down payment, right? But
Mhm.
then those funds would be excluded from your qualified expenditures when you sort of apply for like the allocation next year. That's the thrust of the rule, right?
Yeah, I think that's right.
Okay. Great. I just wanted to make sure I understood that. Thanks.
Okay, Selena?
And similar to Erica, I don't have any concerns about this. We think it makes a lot of sense, and we also think it kind of prevents wild swings if organizations need to pay down a building, which would impact their QEs in the following year. But I had two questions. It's largely around that kind of like de minimis and the other thresholds. So with the de minimis threshold of $50,000 or 10% of IALTA grants, where you don't have to do the ameliorization and ask for advance notice, would that also apply to other state bar grants? Like, could you use a tiny bit of equal access fund, or is that only for IALTA?
I think it would only be for IALTA, so I think otherwise you couldn't use grant funds for the types of expenditures that are listed in the policy. So you couldn't use it for debt service payments or like insurance costs for your property, because they relate to real property, they wouldn't be permitted.
That part wasn't really clear, and so I think it
Okay.
would help for grantees to know that the de minimis threshold is just for IALTA, and otherwise it's zero, except for the what would be the exempt amount, which was like if your mortgage is equal to the rent rate, then it wouldn't apply. Could you use a little bit of equal access fund to pay your mortgage if it's the fair market value of rent? Because that piece also, I assume organizations are doing that now. Or are they not?
I'm not aware if other organizations are doing that now. I don't know if other state bar staff know the answer to that question. But I take your point. I think we could include something here to be a little clearer that these types of expenditures are generally shouldn't be used with other grant fund amounts from.
And I'll get back on stack after Erica, but then my follow-up question to that is, are organizations charging rent to equal access fund? Because it doesn't feel equitable if an organization can charge rent but not the same amount in mortgage. And I'll get on stack.
Yeah, so thank you for those questions, Lena. Some grantees do use EAF for things like their space costs, their rental costs. The concern, I think, with EAF is that non-personnel expenditures need to be tied to the EAF grant. They're not as flexible as the way that the use of IALTA funds is, where you can kind of distribute IALTA as you wish across your non-personnel expenditures, that if you were going to use it for something like your rental costs, you would need to tie it to, for example, like the staff that are working on the grant, right? And so for things like capital additions, if they wanted to use a very large sum of money, it would probably be difficult to tie that back to the actual project that they're working on. And so that was some of the rationale. But I understand your point about if it were a lower amount of funds, if it were below this 50,000, and if it could be tied to the FTEs, that I think historically we potentially would have permitted something like that. We certainly do permit it with rent. So.
Selena?
I wanted to hear Erica's answer before I ask the follow-up question. I do think that organizations will need some guidance on this, because if they have been in the habit of being able to charge rent to equal access fund, and then they purchase a building and their mortgage is roughly what their rent was, it does feel like it will be a little bit of a shock to their accounting practices if they're not able to allocate space. And then I know a lot of organizations will allocate, rent or whatever by FTEs or even by square footage. So a lot of organizations are prepared to do that. So I guess that's just my comment is if it's definitely only, you can only ever charge any mortgage ever to IOLTA, and you're not able to charge it, even if it's the fair market value of rent, to other state bar grants. I think organizations may be a little concerned about that, if that's a major change.
This is Catherine. I feel like there isn't necessarily disagreement about the policy that Erica, which is the current policy, articulated and Selena was supporting. So is there a reason not to make that adjustment to the proposed rules so that people that are currently using other state bar funding to pay for rent in an amount that's equivalent to what they would pay in a mortgage, that they couldn't continue to do that?
Erica, so I know you sort of expressed some of the concerns about the oversight and like and maybe I don't know that it would be allowed for all grants like non-EIF and IOLTA grants, but I actually don't know the answer to that. Do we presently allow like we presently allow rent payments for EF and don't for mortgages, even if it's equivalent?
Well, I think that, yes, we do allow it for rent. And then in terms of mortgage payments, that typically would go on the capital additions line. And we haven't had anything that, like the way that capital additions is currently defined, it would go on that line. We haven't had proposals for that I recall. Like we would have brought that to the Grant and Eligibility Support Committee, and I don't recall seeing that. So that's why I'm saying I'm not aware of a grantee at this moment that's using it for mortgage payments, but I think in principle, the idea if the mortgage payment is equivalent to, the fair market value for if they were renting, I think that grantees could potentially justify that for EIF purposes, if they're tying it, like I said, to their project costs in terms of the staff that are working on it, a proportional cost of their mortgage payment. I just cannot recall off the top of my head seeing that in budgets recently, but in concept, they could potentially justify it, yes, as the grant requirements currently exist.
Yeah, I'll just add for our other grants, if it's tied to like like Erica said, the projects instead of activities, like staff that's working on that, then we let them charge it back. So
Yeah, and I think it's Catherine, and my recollection, we bought a building. I think in the end, we set up a separate, maybe subsidiary corporation that owned the building, but it could only be used for the benefit of DRC. And then we charged rent to that. We were charged rent for all of our grants by that separate corporation, which sort of it achieves the same thing with this sort of extra step to take. And so I guess I'm just trying to make sure the rule works sort of as intended. If you were going to be paying rent and the amount of the rent is maybe even less if you're making the equivalent mortgage payment, it feels like that's a fair comment about what we should allow. And I think grantees would still have to show on their expenditures what they're paying as the equivalent of rent, because it would be part of the administrative cost. Erica, sorry.
Sorry, had a hard time getting off on mute. I guess my question though is, does this rule address EAF at all? To me, like this only read as providing limitations and guidance on the IOLTA part, but for EAF, if you can connect it, as part of, the grant purposes, doesn't that govern how you can, whether you can use the money for mortgage or rent? I guess that maybe that's just something I'm not understanding, but I thought the reason that we created the rule was in part because IOLTA is so broad that we wanted to have certain guidance about what you could do with it in a particular way. Every other grant would have its own set of rules, right? By which you must show some connection to the particular purpose. And so that's what I'm just wondering whether we need to actually address that in this rule, or whether this rule can just be about IOLTA and then every other grant can just be about justifying whether the expenses are for the purpose of that particular grant.
Eric, I totally agree with you. Actually, as you were talking, I was thinking at that as a similar solution. I think that makes sense that this should be IOLTA specific and can defer to the rules of other grants and leave those unmodified by this, and this being specific to IOLTA. I think that makes complete sense. And I think right now, as proposed, there's a footnote saying if funds may not be used for the purchase of real property. I would suggest that could be changed to just say use of EAF funds are governed by the restriction of those funds, and leave it at that.
I think that makes a lot of sense. I mean, I think I would even just take out EAF entirely, right? And say, maybe change it to say, this policy only applies to use of IOLTA grant funds. Other grants administered by the Legal Services Trust Fund are governed by the terms of those particular grants. I defer to you guys in OGC about what's the appropriate language, but that might be the easiest way to kind of address this concern so that as we go, I don't know, just a thought.
So I think the only question about the footnote, I like the solution of the footnote, but the footnote says equal access funds may not be used for the purchase of real property. So is there some place, and it seems like from the bar's perspective, they don't want equal access funds used for the purchase of real property. And this was how they were clarifying it. So is there some other way? Is it already clear that you can't use equal access funds under the rule of that grant for the purchase of real property? I just want to make sure by removing it, which was the last suggestion, that there's not a question about what that means.
I think it's okay to remove that. I think the examples that we were operating off of when we were thinking about these revisions were proposals that we've received in recent years for very large amounts, that it would be very hard to surpass that bar under the EAF requirements to justify the amount that was being proposed in some instances, because they couldn't tie it back to the project activities directly. So, or in a proportional manner. So I think in regard to that it maybe a bright line rule would be more appropriate for things like larger purchases, but in the examples that you're providing would be permissible under the grant, I think, if they can tie it to their program activities. So it would just be in more moderate amounts, right? So
I guess, so you could not have as an equal access project the purchase of a building.
right. Yeah.
That's already clear, right?
It just would be difficult to justify unless, the majority of your work or funding is from equal access funds for, that the majority of your staff, for example, are working under the EIF grant, which is not the case for most grantees. So, yeah.
Okay, are there other comments? So it seems like it's to approve this as modified by, are we removing, Raul, the footnote, or are we just removing the equal access part?
Just the equal access fund.
So do we need to at least note that that in the resolution that it's modified?
Yes. If you give me a second, I can
Perfect.
revise it.
Thank you.
So let me share my where I'm editing. So this would be it.
And just to confirm, the revised version would just have as footnote 1, this policy only applies only to the use of IOLTA grant funds, period. And then everything after that would be deleted.
That's right.
So should we just say as revised at the Rules Committee meeting, maybe not discussed?
Sure.
Okay. Are there any other questions or comments about the proposed resolution?
I'm happy to make the motion to approve it.
Great. Consider this motion you're making, right? Is there a second?
I can second.
Thank you, Amin. Any other comments or questions? If not, Erica Carroll, could you call the roll?
Alsaroff,
Yes.
Connolly,
Yes.
Wong,
Yes.
Mahoney, Sandville, Blakemore.
Yes.
4 yeses, no nos, the motion carries.
Okay, so I think since Brady's here, we don't need to change the order, correct? And we could go to 4.2, so which is the investment policy that I think Sylvia is presenting on.
Yep.
And I think she needs to
We'll promote her.
Thank you.
Hi, everyone. That's only at the top of my head. 1 second.
Yeah. Welcome.
Hi,
Thanks for
good afternoon.
joining.
Yes, thank you for having me. Let me share my screen. Okay. So Okay, so hi everyone. I will be presenting updates on Rule 3.687, the investment policy for grantees to govern how trust fund program funds may be invested and used by organizations receiving those funds. The working group is comprised of Chair Catherine Blakemore and member Erica Connolly. All right, so here's a quick overview of what I'll be covering today, which include updates from the working group, as well as related topics and governing authorities. The purpose of the grantee investment policy is to ensure alignment with the intent of the governing authorities and the fiduciary responsibilities of the commission, as well as the state bar. For grantees, that goal is to also ensure that the proposed rule is consistent with other policy determinations made by the commission. As a reminder, the emphasis of the policy is to provide a fiscally responsible and flexible framework, and one grounded in prudent standards that are adaptable enough to accommodate organizations of different sizes as well as capacities. So of the governing authorities, I wanted to name specific portions for your attention. So the first is Rule 3.681B, which requires grantees to maintain complete financial records, including budgets to account for the receipt and expenditure of all grants and all income earned by a grant recipient from grant-supported activities and interest earned on the grant amounts. The second is Business and Profession Code Section 6217B. Grantees must ensure that expenditure of funds received are done so in accordance with the provisions of the article. And then Section 6222 of Business and Profession Codes, which requires each organization to submit a financial statement to the state bar, which includes an audit of funds by a certified public accountant or a fiscal review approved by state bars, a report demonstrating the programs on which they were expended, as well as a report on the recipient's compliance with the requirements of Section 6217. And so the thing to emphasize here is that across all of these authorities, the through line is permissible use and accountability, including, but not exclusive to, internal controls. So notably, while the intent of the governing authorities is clear, they do not provide explicit guidance on investment and on how related activities should be reported. I'll provide some review of the points of engagement with grantees on this proposed rule, followed by updates from the working group. So as a reminder, the policy uses a principles-based approach that prioritizes core investment principles, namely safety of principal, liquidity to meet operational needs, and prudent return where possible. Without imposing a one-size-fits-all set of requirements, the policy reflects recognition of both the capacity issue and the risk profile of the funds involved, specifically that the funds should be invested in low to no risk investment instruments. Reporting requirements for grantees were designed to ensure that grantees are able to ensure proper internal controls, as well as align with permissible use of funds requirements already in the governing authorities, and to ensure that grantees can document that investment activity. The provisions aim to safeguard public funds while still allowing for discretion and flexibility on the part of the recipient organization. With that in mind, the investment policy is also explicitly aligned with the State Bar's investment policy, though notably much more conservative. As part of the development of the policy, staff reviewed best practices from IOLTA programs nationally, as well as legal services corporation guidelines and rules, California public agencies with comparable fiduciary responsibilities. It also reviewed board-approved investment policies shared by grantees. The working group engaged grantees through multiple rounds of feedback to ensure that the draft investment policy, the proposed rule, reflects input from grantees and their operational realities and aligns with the Commission's commitment to fiscal stewardship as well as flexibility. So I'll highlight some of those points of engagement with grantees. So the first feedback session was on June 6th, of this year. And at that meeting, grantees universally supported the development of a policy framework to guide investment of trust fund program grant funds. Key questions from that session focused on two areas. The first was whether investment would be mandatory, and we clarified that investment is entirely optional. The second was whether investment income must be spent within the grant term, and we explained that while all funds must comply with applicable statutes and grant conditions, there was no requirement necessarily that funds be spent within that same fiscal year that the grant was allocated. There was a written comment period facilitated with the Legal Aid Association California between July 25th and August 8th. And most comments focused on reporting burden and the structure of the policy. So based on those comments, the draft was revised to integrate reporting into the existing IOLTA EAF application process to streamline efforts. We also removed the requirement to report investment type and liquidity status, which grantees found to be too onerous. And we clarified also in the revision that grantee boards, rather than the commission, would be responsible for reviewing investment activity. We held the second feedback session last month on September 7th. And that session had two goals. It was to gather feedback on the revised draft rule, as well as present and collect input on two potential reporting options for investment income. In advance of that session, we invited grantees to share their investment policies, and those documents gave us valuable insights into existing investment governance across organizations. And so some of the insights from that analysis, so despite variation in size and structure, most of existing grantee policies emphasize the same core principles found in this rule that include preservation of capital, liquidity, as well as prudence. And most of those policies also shared with us establish a clear oversight structure with fiduciary responsibility residing with the board of directors, often delegated to a finance or investment committee, and day-to-day management typically falling to the executive director or a finance director. And so in that last feedback session with grantees, staff presented two potential reporting approaches following the rule. So the first approach is segregated tracking. Under this approach, organizations that invest their funds in separate accounts would report the actual investment income earned on those funds. In addition to reporting the income, organizations would be asked to certify that their earnings were used solely for activities permitted under governing authorities, including state bar rules and grant agreements. This method often offers a clear audit trail, but may be more relevant for organizations that already segregate IOLTA funds and other funds for operational or compliance purposes. The second approach is a pro rata attribution for pooled accounts. So for organizations that pool funds with other resources in a single investment account, this approach would allow for a pro rata allocation of investment income. So the pro rata share would be calculated based on the proportion of funds, state bar funds, relative to the total pooled balance by the time income is earned. Organizations would be expected to inform the amount attributable, in this example, to IOLTA funds and the use of those earnings for permissible legal aid purposes. This approach is consistent with standards in nonprofit accounting and may offer and have the option of offering greater flexibility for pooled fund management. Under both approaches, whether that be pro rata allocation or segregated tracking, the reporting mechanism would be the same. And it would be done through the annual IOLTA and EAF application, and that information would be validated through the triennial monitoring visit. Also going back to that second feedback session with grantees on September 17th, grantees also raised two other major concerns. So one was implementation support, and for that, grantees requested that we share sample model investment policies, as well as templates to assist with pro rata allocations or segregated tracking, for pro rata calculations rather, for funds when they're pooled. And then the second concern raised was whether or not was on the question of authority over investment income. So some grantees questioned whether investment income is subject to the same use restrictions as the grant itself. And they asked for explicit citations supporting the Commission's authority over how such income is tracked as well as used. The concerns that were raised by grantees during that session were taken seriously by the working group. And in response, we consulted Office of General Counsel, which affirmed the Commission's authority to regulate the use of investment income earned on trust fund program funds. The other thing to highlight is that through every phase of the process, the working group has really tried to balance flexibility and administrative and operational flexibility with the need to hold the fiduciary responsibilities of the Commission as well as the State Bar. And the staff as well as the working group recognize that flexibility in implementation is also important, but so is clarity, both in terms of how funds can be used and why the standards are important. The governing authorities are also consistent in their intent. So all funds administered by the Commission, including IOLTA as well as other trust fund program grants, must be used exclusively to support the provision of civil legal assistance to indigent Californians or for support centers to qualified legal services projects. This includes both the principal of the grant and any investment income earned on those funds. So for example, Business and Professions Code sections 6212 and 6223 established that the use of funds must be restricted to eligible legal service activities. And section 6218 is especially clear, and I quote, funds appropriated pursuant to this article shall be used solely to defray the costs of providing legal services to indigent persons. It also states that IOLTA funds may not be used for activities not permitted under the IOLTA statute. The Commission's authority to regulate the use and investment of these funds is also granted in statute. So Business and Professions Code 6225 authorizes the Board of Trustees to adopt regulations to ensure that trust fund program funds are managed and expended in accordance with statutory requirements. And this includes rules for how those funds may be invested, provided that any resulting income is also spent for permissible purposes. And so while we understand that some grantees raise concerns about whether investment income belongs to the organization and whether it is subject to the same use restriction, the answer on the answer to the question if income on whether income is subject to the same use restrictions is a yes. That income derived from public funds must be used in the same way as the principal, again, to provide legal services for indigent Californians or other purposes expressly allowed by statute. And so that is the end of my set of updates before I go to the resolution, but happy to answer questions.
Are there any questions from members? Okay, no questions. I know we got a comment earlier today. Does that feel addressed?
Yes, so I'm happy to summarize the comment.
Thank you.
So I believe that the concern was on the timing for expenditure, investment earnings, and related reporting. And so I believe that there was concern that investment income had to be spent down. And the interpretation based on the proposed rule was that it had to be used within the same fiscal year. Given that IOLTA funds can be spent down over a 4-year period, there is no explicit language on a spend down period for investment income in the rule. So the suggested revision to the rule was to one section on annual reporting. And so it is possible to finesse some of that language, but as it stands, I believe that the language in the rule is sufficient based on existing statute that based on existing spend down timelines for funds, and without explicit language in the rule that investment income has to be spent down in a specific period. So one option is to keep the language as is because that flexibility is there. The other is to amend, not necessarily according to the suggested revision, but that it's, again, reiterated that the funds have to be used only for permissible purposes, but that language already exists in the rule.
So Sylvia, just so I'm clear from what you just said, so do the funds then have to be spent within that 4-year period of time? Or you're just saying there's nothing that the fact that the regular grant can be spent over 4 years means there isn't a 1-year period of time for any reporting, but there is also no timeline for this expenditure of investment income.
Yes, again, going back to the existing rule, existing spend down timeline for the IOLTA grants, to follow that precedent or practice without specifying a strict spend down period was something that we discussed and was raised earlier during an earlier feedback session. And so the goal was to not kind of like over prescribe that kind of language, to give grantees flexibility.
Yeah, so let me just state it so it's really clear. There has never been like a spend down period for investment income, and I believe in this rule and the working group they are not proposing one. So I think the concerns from Impact Fund are it's not there because there's not a spend down period.
Thanks, Dawn. Selena?
I think either in the rule or somewhere it should be clear that there's no spend down period, because I heard that comment from a few organizations that they it was unclear to them whether they needed to spend the interest within a particular time frame. So if the rule allows for that flexibility, at least in a memo or in guidance, it should say
it's in the last memo. It's in the first memo during the August 28th. Okay. Yeah, that in response to the lack facilitated feedback on spend down, that it was intentional not to include it to, again, over prescribe. So that's in the August memo, and it's not in this one because it was addressed in that last one.
But we could pull it into like implementation, like our materials, and because Sylvia, I don't believe like right now we don't have like a reporting like an expenditures report for investment income. I don't think we're contemplating that either, right? Just to be clear.
Right. Yeah.
I think that would be helpful because most grantees won't go back and read memos from this prior year, and we'll get a new grantee in 5 years. And if there's any confusion, just making it clear that they're accurately tracking that. So that they, if they spend it in a future year, they'll make sure it's for qualified expenditures.
Okay, so the suggestion is that we remove, there's no spend down period required from the August memo to this memo, and it'll be backup information, but there's no need to change the proposed resolution as I hear it.
Yes.
Okay. Any questions about that or an approach? Okay, is there a motion to approve?
I'll make the motion.
Thank you, Erica.
Mhm.
Is there a second?
I'll second it as well. And thank you guys for digging into this. And thank you, Sylvia, for the presentation.
Thank you.
Yes. Thanks, Amin. Okay, I'm not seeing any other hands for comment or discussion. So Erica Carroll, could you call the roll?
Elsaroff,
Yes.
Connolly,
Yes.
Wong,
Yes.
Mahoney, Sandville, Blakemore.
Yes. Just adding my appreciation to Sylvia for her clear presentation and flexibility about going back and thinking about this and presenting it again.
Thank you.
Thanks very
Yes.
much.
Sylvia's done a lot of did a lot of heavy lifting on this. And so I also want to share my gratitude for that. And Catherine, thank you for kind of joining in our working group when we sort of had some people switch out and helping it get across the finish line. And lastly, big thanks also to OGC for giving us like some clear information on our authority. So thank you all.
All right, we have clarity on this rule. That is a good place to end. So thanks, everyone. I think that takes us to item 4.3, which is the Rule 3.680 regarding financial application documentation and extension request.
We're just promoting Lauren, who will be presenting on this topic.
Terrific.
Hi.
Hi,
Good afternoon.
welcome.
Hi, nice to meet some of you. I'm Lauren. Let me get my screen share going. Okay. See my screen?
We sure can.
Yeah.
Awesome. All right, thank you for having me. I'm here to present item 4.3, the approval of a recommendation to amend State Bar Rule 3.680 regarding financial application documentation, and hoping to get this out for public comment. Okay, first I'll give a little bit of background since this is the first time you all are hearing a substantive discussion on this item. As such, I will talk a little bit about the current rule and state bar practice, and then I will propose the changes that are outlined in the memo, identify some of the impacts of those changes, and then of course I'll present resolutions for you all to consider. So as you all are aware, financial documentation is a critical component of IALTA and EAF applications. The governing authorities are Rule 3.680, in particular E1, and also Business and Professions Code 6222, which require applicants to provide either an audited financial statement or an audit, or a financial review that's prepared by an independent CPA. Applicants with gross corporate expenditures less than 500,000 actually can provide a financial review, again, prepared by a CPA in lieu of an audit. And as you can imagine, this provides flexibility for our smaller, less resourced organizations in meeting the IALTA EAF application requirements. An audit is considered a higher level of review and requires a CPA to disclose any significant issues regarding the nonprofit's organizational controls. And lastly, the audits and financial statements are due on May 1st of each year. So first, in terms of current practice relevant to the proposed changes in the memo, The current rule does not have specifics about the documentation that's required as part of the financial statement submission, although most organizations do provide what is called a statement of functional expenses in the accounting world. A statement of functional expenses is a standard financial reporting practice, again, in nonprofit organizations, that basically shows how costs are allocated by function and then type of expense. Secondly, in terms of extension practices, State Bar staff can grant an extension to an organization for either its audit or its financial review submission up to the application deadline. Beyond the application deadline, the commission has the authority to grant an extension for submission of an audit or a financial statement. And upon demonstration of what are deemed extraordinary circumstances. Lastly, if there are no extraordinary circumstances, the commission may nonetheless grant an extension with specific conditions. And as you probably know, the State Bar staff are responsible for elevating potential extension requests to the commission each application cycle. So discussions with the commission have surfaced some recurring challenges with extension requests during the application cycle. This includes namely condensed timelines for State Bar staff to provide technical assistance to applicants when looking at their financial materials. When we're looking at financial documentation, again, some of the concerns noted, there have been financial documents submitted with errors or potentially submitted very close to a deadline with unresolved errors, and then the need to resubmit after the extension deadline, which brings into question applicant readiness to, of course, submit accurate documentation, but then to enter into a pool of grantees. Applicants, especially those that are not yet funded or don't have an award in the current year, often require several months or at least weeks of technical assistance to prepare for their applications. Late audit extensions, or to be more specific on that, audit extensions that are granted really late into the application process force the staff to condense those months or weeks of technical assistance. And also, as you can imagine, that strains staff capacity to provide, even technical assistance to other applicants, and just general capacity concerns in the grant making process because of this practice. Allowing late submissions, again, also tends to erode expectations that new applicants can demonstrate, compliance and that they're ready to be grantees. To summarize, the current practices create operational efficiencies and some resource burdens for staff. And so, as the memo suggests, these discussions at the commission level have signaled the need to revise the policies. So the first proposed change is to make clearer, or rather revise, extension policies for what we're calling unfunded applicants. This would move extension language that's actually currently only in the schedule of charges and deadlines up into the rule 3.680 into the rule itself. The changes proposed specify that unfunded applicants or those without a current award must submit financial documentation by the application deadline. And so again, the changes were moved from the schedule of charges and deadlines up into both sections E and F of the rule. The second change is to require a statement of functional expenses for financial review submissions. The revision of this rule is names and defines that term in a blend of accounting and lay language. Again, this is codifying our existing practice, as typically applicants are already providing this statement. So it's just making explicit what we've already been doing in practice. So again, just really briefly, the impact of these changes. Starting with naming the statement of functional expenses, as I mentioned, we're just codifying existing practice and being super clear about our application as a practice that we're already doing. as part of submitting a financial review. Further, we think the changes will allow staff to better assess applicants' financial and organizational practices while also addressing workload and timeline challenges that I've talked about in the application process. These changes also make sure that our new applicants are demonstrating that readiness to be grantees and, of course, demonstrating their financial compliance before, again, they're entering the potential pool of grantees. And we also want to maintain accountability and fairness in the grant making process. So just being really explicit about what we expect. Not on this slide, but also just wanted to thank Legal Aid Association of California, LAC, for engaging the legal aid community in some informal feedback on the proposed changes, again, ahead of and separate of the public comment. On October 11th, we did get a letter from LAC that expressed strong support for these changes, and they heard no concerns from the legal aid community with our initial proposal. The California Project Directors Association, which is a cohort of current IALTA EAF grantees, also there's an attachment to the memo in which they also have a letter, and they've expressed support for the proposed changes here. Okay, so these are the resolutions. Happy to, this is my first time doing this, but just to summarize, I'm happy to read these afterwards. The first asks for your all's authorization to make the revisions available for public comment period. The second is asking that the committee recommend to the commission that they are able to delegate to staff to present directly to the Board of Trustees for approval of the revisions without returning to the commission after public comment, should no substantive comments be received. This is to facilitate just hopeful adoption of these changes in anticipation of the 2026 grantee cycle. And with that, thank you so much. I will leave this slide up and pause for you all to discuss.
Thanks, Lauren. Thanks for the really clear presentation. Appreciate
Of
that.
course.
Are there commission members who have questions or comments about the materials or the resolution? Dwan has something
I
to
just
say.
wanted to clarify a couple things. I'm not sure I heard Lauren say this, but so this topic is coming straight from as a staff recommendation to the committee, and then it'll go obviously to the commission. We wanted to kind of do this a little bit out of process to speed up the process, because as Lauren mentioned, if we're able to hit all these things and the commission releases for a 45-day public comment, and assuming there is no kind of changes, we'll take it to the board early 2026. That means that we have a fighting chance of getting this into effect before we release applications for the 2027 application cycle. So that's why we're doing on this kind of very expedited timeline.
Thanks, Dwan. Erica.
Thanks. And thanks to staff. I think this is like a really important issue. So appreciate you guys like taking the time to do this. One thing I just wanted to make sure I understand is, so State Bar staff, whether it's a new applicant or an unfunded applicant or because it could be not new, right? In theory, someone who had like lost eligibility but then came back would still fall into this unfunded applicant situation, right? So State Bar staff can then grant that extension to them up to the deadline, application deadline, which is consistent across the board. And then basically that's it, right? There's no way to grant an extension beyond that, which I don't have a problem with. The one thing I just wanted to ask is, the rule doesn't seem to say that explicitly. It sort of implies it in the negative by saying you can only grant it in these circumstances. And I just wanted to make sure I'm fine with that. I just wanted to make sure, because it is not explicit, like we cannot grant them past this, that there's no, if we want to make that explicit, like, just want to make sure if that there isn't some sort of intent to have like leave room for equity or anything like that. That's the only thing I noticed, was that it doesn't say explicitly.
Well, we contemplated, we want to actually provide a way with the discretion because then it's just a hard deadline. I think that's easier for us administratively. But if you think actually the
Yeah.
word language is like confusing and it should be opposite of in the negative, because I think we did talk this through with OGC, not Raul, but another OGC attorney that handles the rules. And this is where
Yeah.
we landed on. But if that's what you prefer, maybe we can ask Raul if that's a change that could be appropriate. But I know we did work it out with OGC, that language specifically.
So Dawn, I'm actually now confused. So is the rule a hard deadline or you think there's flexibility?
No, we didn't draft it with flexibility. So if that's reading like there's flexibility, then that's not the intent, right, Lauren? My understanding is the way we drafted it is to take away that discretion from the commission.
Yeah,
So-
I think
so here's-
Erica's
Yeah.
saying, oh, go ahead.
Go ahead.
Yep.
I guess all I'm saying is like, this is me being a little bit biased towards
Yeah.
the commission, but to me, if we don't have a rule that says we don't have the power to do something, I think there's an implicit ability to have the power to do something. So I just have a little concern that if in one instance, it's like, we can only do things that are laid out in the rule, does that mean in
Yeah.
other instances, we can only do things that are laid out in the rule? Or do
Sure.
we have the power to do things that are not laid out in the rule, implicit in our, that's
Gotcha.
the only thing I'm worried about is this interpretation of like, only if we do, like, these are the only
Yeah.
circumstances, instead of just taking the power away.
Sure. But are you
and
don't
being
have a
explicit. I don't have a fundamental problem with the issue,
fundamental,
with
okay,
the
on
policy.
principle of it. Okay.
No. Love the
Okay,
policy.
so-
I think it's great. It's just a matter of like making this consistent with other ways in which we drafted rules, and to like make sure we're not tying
Yeah.
ourselves in other situations where we maintain
Sure.
that there's certain flexibility outside of the rule, or you know what I mean, or that we can do something even if it isn't explicitly spelled out. That's all.
Raul,
Nothing to
you
do.
have an
I
opinion on
like the
that?
policy.
I know you
Want to
weren't-
support that.
Yeah. I know you weren't there, Armin is the one that consulted with Lauren on this, but I don't know if you
Yes,
can give us some
sorry.
guidance on this.
I just wonder, like, could someone pull up the
Yeah.
language that Erica's referring to? And then while she's doing that, let's take Selena's hand, which
I
was
have it. I'll share a screen for that.
whoever can do that, it'll be great. In the meantime, Selena?
Sure. And I saw the same thing, that it says, this is when extensions can be granted, but it doesn't explicitly say no extension. So I think that's probably the concern. And then related to that, I know that the commission has given staff the authority to accept late budgets. And I think, 1 business day seems to happen pretty frequently. And so I think that new applicants who are currently unfunded, or returning applicants who are currently unfunded, may need to have real clarity that even a 1 business day is not allowed, or if it is allowed, making that the kind of exception. And I noticed for the meeting tomorrow, in which the budgets will be discussed, of the 5 organizations that submitted budgets late, 4 of them are relatively new and 1 of them is brand new. And so just having real clarity about what the deadlines mean and when there is extensions or not will help newer grantees.
So I guess, yeah, like, where are we seeing, sorry, the flexibility? I haven't looked at this since this went to Armin.
Well, is it the flexibility? I'll find.
Well, it's just it's in pages 7 and 8. It's not that I'm saying there's flexibility. What I'm saying is that we tend to interpret things as we can do some, we do not tend to say that the only way we can do something is if we list it, right? So, but this suggests that. This says we can only do it in these circumstances, which means if we don't explicitly lay things out, it's just a fundamental like baseline interpretation difference, right? Is the assumption that we have the power to act within our statutory like realm, and then there's certain rules that codify how we're going to do things, and that only if we say we're taking certain discretion away from us, we otherwise have that discretion? Or is the interpretation that we only can do the things that we lay out that we can do? This is not about this rule. I like this, the principle of this. It's just, why can't we just say the commission may do these things, and then add a line that says under no, there will be no circumstances in which you will accept an application after, for an unfunded applicant past the application deadline. Like, just be really explicit. And then there's not this issue later of like, well, you know, I just don't want to run into any issue where later we're like, well, in this case, we spelled out what we could do and then we couldn't do anything else. When I think in other circumstances, we've tried to say these are examples of things we can do, but they are not the only things we can do. Maybe that is that's not really a big problem, but I just wanted to flag why we weren't just explicit about it.
Yeah, so
Yeah.
thanks, Erica. And I think Amin had
Yeah, I mean, I totally hear what you're saying. I sort of read in F, like larger F, the next paragraph, the next section.
As saying
that said it a bit more explicitly. We can't, neither the state bar staff nor the commission may accept audited financial statements or financial reviews that are not timely submitted pursuant to section E1 of the rule. I don't know if we need to make it more explicit. I don't know if that is that sort of what you're thinking about as far as explicit language in that respect.
That's
fine. I guess
can't.
it's sort of, can't you just say the state like may not accept or cannot accept it sort of starts with this neither, right? May accept. It's almost like it's an odd way to say a negative, I think. Like, isn't it more affirmative to say the state bar staff and the commission cannot, which is there's no discretion. You cannot do something, maybe.
Can we just make that change now, Lauren, and then we can see what it looks like, and then if everybody's satisfied? So maybe not with, it's the neither, that's, I think.
Yeah,
I just
I
think
agree,
like
it's the neither. So just the state, but they
the
state
state bar staff
and the commission cannot.
cannot, rather than have a may. And then section E1 is unfunded applicants, right? Whoever has background noise on, if you could mute, that would be really helpful.
Oh, that's probably.
Thank you. I just want to be clear about what the reference to E1 is, because it's hard to follow when it's on the screen.
Could you scroll up a little bit, Lauren? Because E1 is.
So that's probably the one, if E is right above it. E, an application must include so doesn't that apply to all applications, not just unfunded ones? So the reference seems wrong.
Yeah, the
Can't we
reference
just,
seems wrong.
so can't we just say to unfunded programs, like just be clear in that sentence that it's to unfunded programs, not to the E1 process, which is kind of just hard to track anyway. And I think wrong.
Yeah, I
Okay.
agree with that.
My recommendation would maybe just be to run that by Armin. He had specifically wanted it to reference that section, so.
Well, it can't
if we
reference
think
that
it's wrong-
section. Yeah.
Well, it's wrong, Lauren, that's the problem, and he's not here, so
Can we just make our
Charles is
proposed
proxy?
changes and know that you're gonna run it by somebody? Like, but it's intended to be for unfunded applicants, as I understood your presentation.
Yeah, it is.
So
Okay.
go back down to the F1 or whichever one we were just F, I think.
I mean, I think it is relevant because those exceptions that continue in those bulleted sections are about current grantees,
Right.
right?
Yeah, I
And
mean,
so this would be other than current grantees.
but I think I take Lauren's point in that we might want to just read over the whole thing just to make sure that it was
Yeah.
like very fine tuned. But perhaps we can make the change now, and then if you all will give us that ability to go back and work, just take a closer look.
I just feel like the change really is not a reference to E1. I don't
Yeah,
think,
I don't
'cause
think it's right
that's
either.
everyone, not timely submitted by whatever language, I think you said currently unfunded or unfunded, whatever the unfunded applicants. And then which should go in that F section, I think.
Mhm. Okay, so, sorry, Erica, Carol, you're sharing. Can you scroll back down? I think
Sorry,
we're
I
saying,
forgot who was
no,
driving.
it's okay. Erica's helping me out.
That's
Okay. The State Bar Staff and Commission cannot accept audited financial statements or financial reviews that are submitted past the deadline as set forth in the schedule of charges and deadlines, comma, by unfunded applicants or something like that. Is that what we're saying about? Okay. Okay.
Are you gonna type that in?
I think I'm like reading this back through that section though applies to everybody. So don't we, if we limit it to just to unfunded, then we're sort of taking out the references to when things are due for the current grantees as well, which is what that section is about. And I'm a little nervous about us editing it on the fly right now.
Yeah,
That's
why if we can go back and just read the whole
Okay,
thing.
so the intention is, so if we're gonna pass a resolution, which I understand would be helpful for that to happen today, right? Then the resolution would need something that says we're approving it with a change to the section, and refer to that and what the change is about, I suppose, so that it's just clear.
Can you say like you're approving it in principle? And staff will work with the Office of General Counsel to fine tune to make the language more clear or something like that?
We
That's too
can't,
much?
I'm just trying to be clear in the resolution, what we're trying to be clear about.
Well, I think it is that sentence. I think we've isolated that neither, but I do think it's because it's within that
I
section
agree,
that talks about
I
every.
actually agree that it needs its own section. I
It needs
think
its own
to Amin's
section.
point, that it's not just the reference to the E, it's just the structure of it.
Should we say to be consistent with the recommendations in the memo? I mean, isn't that, I think we're all in agreement about what the goal of the changes should be that's described in the memo? Is that, does that do it, or?
Is the memo, and the memo's clear that it's just to unfunded
Yeah,
applicants?
the memo is very clear in that.
Okay, so
And the
that's
other thing we could do is,
fine with me.
since we don't have a working group, maybe Catherine, if you have a few minutes, we could just share that language with you once we have it from
Sure,
MPC.
that's great. Yep.
Okay. So we want to follow the intent of the memo and consult outside of the meeting, but you all want to approve a resolution. So, let me, I'm trying to think and
Okay,
listen at
Lauren,
the same
let
time.
me do this. Erica, can you
What-
help her with the motion and what the wording should be?
Um, something like that.
I don't even know if we need that anymore. I think we will, but yeah, that's fine too.
I think maybe towards the end of it, saying, because we haven't revised it yet, so just say after revisions.
Didn't we have a working group? Wasn't there just two of us that were on some review of this?
No, that was for the overall, and then we,
Oh, the overall.
yeah,
Okay.
yeah, it wasn't for this. It's just for the.
Those revisions. Does that make sense?
It sounds clunky. It makes sense, but it sounds clunky.
It's really capturing the intent for no audit extensions for unfunded applicants. I don't know if you need to say you're going to consult with
Yeah, I
OGC.
don't
It just
think-
feels like however you do your work, you're going to do your work.
Sure.
I would say after revisions by staff, and then so it's and unless anybody has any other changes, I'll make that motion for both of these resolutions.
I have one quick change, just in front of extensions. Maybe
Mhm.
put like audit and financial review extension or something like that, so we know what extensions we're talking about.
Yeah, definitely. Okay. I think that's what we're calling it.
Okay. With that,
I don't know,
it-
that's not it, Laura. It's not, it's not allowing us to accept the financial statements and audits. I think that's the more clear language,
Yeah.
not financial
Well, it's
documentation.
the financial reviews and
Yeah, it's the
audits,
financial
right?
review and the audit, sorry, excuse me, yes.
That's okay. We'll get there, Tuan. 6 cooks in the kitchen while somebody's trying to type this. That's pretty amazing.
Okay, does that look okay?
I think so.
Should I read it?
I think it's fine unless someone wants it read. I think we've all seen it.
I don't.
Okay.
So moved.
I'll
Thanks,
second.
Amin. Thank you, Erica. Any other questions or clarifications? Thanks to staff for working through this with us. That's great. Okay, Erica. Nothing else? You can call the roll.
Did we lose quorum?
Yeah,
Tony dropped off.
we did, yeah.
Do we have a way to reach her to ask her to quickly get back on?
Yep.
No.
I think we can try to message her. Hold on 1 second.
So close.
If we can't get Tony back, can this go just straight to the commission without us having to
It can't
approve
go straight
it?
to the commission, but then
Okay.
we can't put it on consent. We need to pull it back into the business item.
It's still better than not moving it forward.
Yeah.
Okay. I don't think this will be particularly controversial at the commission meeting, so I think it could be a pretty quick presentation.
Yeah. Why don't we do this? Why don't we just pause this, see if we can reach Tony, which would be the easiest if we can. And then, do you want to talk about the work plan? Well, because that's we're not, as we said at the beginning, we're not doing 4.4. So that leaves us with the discussion of the Rules Committee work plan and meeting dates. So why don't we do that while we're seeing if we have people vote?
Okay. For item 4.5, just wanted to briefly kind of go over the work plan, the tentative work plan for 2026, which, as we all know, is subject to change kind of as things move along during the year. But this document has the history of sort of all of the codification changes that have gone through. And once this is finalized, I'll be happy to reshare it with the committee when it's ready. But you can see at the top here, which I alluded to in the staff report, we have a number of items that are going to the board in November. So those will hopefully be finalized. And then the rows that are in white are things that we are either addressing this year that haven't moved forward yet, or are slated for 2026. So the items for 2026 that we have are are either longstanding ideas that we've intended to address or ones that have come up this year that are kind of new. And I think staff might need to explore the appropriateness of a rule change versus, potentially other more, practices and procedures. But the first one is the established compliance rate and leadership bank program. So if you're familiar with the leadership bank program, banks can commit to a certain interest rate on their IELTA accounts and establish themselves as leadership banks with recognition through the state bar. Banks that don't want to use the higher interest rate, there is a calculation for an established compliance rate, which is the interest percentage that they must have be at or above under the statute. And so just revisiting that program, the leadership bank program was established, I think, about 5 or 6 years ago. And the established compliance rate hasn't been adjusted, I think, in quite some time either. So just revisiting sort of the structure of that program and whether any changes need to be made there. Then I know we've covered a lot of fiscal issues already, but additional fiscal issues that have been flagged are clarifying the requirements for indirect costs. So providing definitions for administrative and program costs, moving in the direction of a direct versus indirect cost breakdown, which is a little bit different than how we do it in our budgets currently. And then reviewing reporting related to statutory spending requirements. So with our qualified legal services projects, for example, in the statute, they are required to spend 20% of their IELTA and EAF funds for disadvantaged or underserved groups. And so creating a mechanism for reporting on that, which we currently don't have. We do ask them to describe how they will be spending their funds, but we don't have reporting related to this currently. And then line 28, request for reconsideration. So in recent years, we have on occasion received a request for reconsideration when an applicant was denied funding. But the timing for reconsideration versus the timing of the grant process moving forward are currently out of sync. And so investigating whether changes need to be made to that rule. And then line 29, clarification that receipt of pro bono allocation is contingent on continuing to run such a program. So the pro bono allocation for QLSPs is available if they have a principal means of service delivery through pro bono. And organizations can apply and they receive additional funding as well as the ability to use a higher income threshold when they receive these, when they're eligible for this allocation. And there had been an inquiry, I think there had been a question at one point if a program establishes eligibility based on retrospective, that we're looking back at their prior year's expenditures and their service model. But if they have a shift in their model, that they're no longer going to be a pro bono program or not primarily pro bono, that, eligibility for the allocation is contingent on them continuing to actually be a pro bono service provider. So that might be a minor clarification needed. And then tangible personal property guidelines. So we just went over the real property purchase guidelines. We also have a tangible personal property policy that is also from the 1980s and hasn't been revised since then. And so taking a look at those to see if any updates are needed. And then other fiscal issues. So the procurement policy or compliance with federal grant requirements was something that had been floated as a possible topic. And support center deeming. So we're still working on the support center topic as it pertains to things like primary purpose, statewide work, significant level of services. But then we had also deferred the question of deeming as something is a separate topic. And so will also be addressed in the coming year as part of the overall support center work that the committee has been doing. And then in terms of proposed dates, these are tentative, so they are not set, but just wanted to share dates that we are looking at for the committee. We are still working internally to set dates for all of our committees to make sure that there's no conflicts. So subject to change, but did kind of want to give you a preview that we're anticipating 5 meetings in the coming year, and that they'll try to be sort of spread out at kind of 2 to 3 month intervals. And that first meeting in February, or that's tentatively set for February, will be devoted entirely to support centers, as Catherine had highlighted in her report.
So if members of the committee had any concerns about the dates and not working, then they should let you know, Erica, just so that you have that information before finalizing them. So
Yes, please feel free to reach out to me if you have any dates that you know for sure, even if they don't overlap with these dates, like I said, because we are still kind of doing kind of shifting around with various committee dates. So if you have any major or kind of like long periods of time that you might not be available, please feel free to let me know in the meantime.
Other thing I do want to note is, usually we do a little bit of a shuffle for the commissioners for the following calendar year. I don't actually know if that's going to happen. That's one thing that's the executive committee was going to talk about tomorrow, because there aren't like usually we're cycling off of commissioners and then having new ones in. That's not happening this year. We don't have any terming off or coming on in, so they can stay as is, but staff will have a couple recommendations for some movement. So I just say that because there might be some shifting, probably light shifting around. If anything, I think this committee might add new members. I feel like it is a little bit light. That's something that Erica and I have both talked about, and I think Catherine, you and I have talked about. But I want to note that too, because things might shift.
okay. Thanks for that, Dawn. Any other questions or comments about the proposed work plan? I like that you started with all of our progress. It made me feel good, at least. Go ahead, Erica.
I just had a quick question, and this may be on there and I just didn't see it. I know that I had worked on a lot of like internal controls and fiscal rules. What's the status of those?
Those are the ones going to the board in November.
Perfect. Okay. I
Yes.
just was having a little moment of like,
Yeah.
are those passed? Okay, cool. And I will also say, you guys always do an amazing job presenting at the Board of Trustees, but if you ever need like any commissioners to join, please, I won't speak for everyone else, but I'm happy to like try to sit in or join if that would be helpful. I'm sure you guys will handle it fine on your own, but just wanted to make sure that you knew that was available.
Thank you.
So much work, but we made a lot of progress. All that grayed out stuff was great. I agree with you, Catherine. I was like, woohoo.
No, it did feel good to see that. Selena.
I don't see any major like calendar conflicts, but I did just want to note that October, there's a lot of Jewish holidays in October, so I was checking that, but I don't know if you've already checked October.
I believe we did, but it's always good to double check.
I think October 2 next year is when the Cal Lawyers Conference and Judges Conference is. This year was in September, and so there's at least they're at the same time. So I looked at them yesterday. It might be around the 22nd or something.
And Catherine, your availability is probably the most important.
I gave Eric my availability. Yeah.
I mean, there's so many things. I mean, we accounted for like the Access Commission, we accounted for like the ABA, conferences, we accounted for our Board of Trustees, the holidays that we were aware of. But yeah, if there's anything else, then we just let us know.
It does not conflict with Rosh Hashanah, which is usually what I'm looking for in October. We have
Sometimes it's in September too, I think, but it's easy to find.
Yeah, I mean, I'll send an email as well, but I'm in trial starting April 13th. So that's the 17th. I probably won't be available, but if everyone else is, like, I don't want you to feel like you have to schedule it around me, because I'm not sure that trial is probably going to go 2 weeks, but it may not go 2 straight weeks.
So it looks like it's in September in 2026, Selena, Rosh Hashanah. Okay. It seems like we were not able to find Tony.
Yeah,
So-
unfortunately,
So
reaching
it
out.
can still proceed on the 7th, and there's a mechanism to do that, and that means you have time to address the question, and that'll be great. But really appreciate the work that went into that memo, because that was really all staff that did that quickly. So thank you. Okay, I don't think there is anything else. So I think we are ready to adjourn, and sure Erica will be sending us the committee dates when they're available, and everyone will probably see one another on November 7th. So thank you very much. Take
Thank you.
care, everyone. Bye.
Yeah.